So let's talk about your children and searches at school. My name is Brian L. Jackson. I'm a Tulsa attorney, and you are watching Oklahoma Law Made Simple. And today I want to talk to you guys a little bit about the particular case of searches in the context of a public school and also in the context of a private school. And yes, the rules are a little bit different depending on if you're dealing with a public or a private school. Starting with the public school, certain principles of general search and seizure law do apply. Your searches have to be reasonable. However, there are some additional rules that apply in the specific setting of a public school because of the nature of schools. Schools are allowed to conduct reasonable searches for the purposes of maintaining security of the building or maintain order. And the search conducted under these circumstances does not require probable cause. Furthermore, it's been well established too that any government building, they can set up security at the door, and your entry into the building is conditional upon you passing through a metal detector. Many schools have these, and that's also 100% permissible under federal constitutional law, as long as the state law doesn't prohibit it. They can do that. Now, if the school is doing the search for the specific purpose of law enforcement, they have to have probable cause, and it still has to be reasonable. They can't, for example, decide to strip search your child on suspicion of having cigarettes. Now, if there's a weapon suspected, then they may be able to do that, particularly if you were talking about something like a firearm or a blade. But it has to be reasonable. That's the key thing. It's just like, in another context, the cops can't rip the stuffing out of the seats of your car seats because they think you have an open container of alcohol. But if they have reason to believe there's a large quantity of drugs hidden inside the seat and they have probable cause, then yes, they might be able to do that. So that's kind of the brief overview of search and seizure law when it applies to public schools. Let's talk about private schools. Now, a key thing to be aware of with private schools is that they're private. And that seems like it's self-evident, but the reason that that's important to remember is that in the context of a private school, as a general rule, the federal constitution doesn't apply because they are a private entity. They're not the government. And a key thing to understand about constitutional criminal procedure is it applies against the state and federal government and the local government. It does not apply against private individuals. Where your child's rights would come into play would be potentially under state statutory law. There may be other areas of state constitutional law that apply. And under contract law, what are the terms and conditions of the child's enrollment contract? Now, under Oklahoma law, some laws that would definitely apply in the context of a private school. Obviously, again, the search would have to be reasonable. Even by the private school, they can't strip search your child, again, probably not on suspicion of possession of cigarettes, for the reason that that could be considered unreasonable, and it could cross some lines under Title 21 dealing with certain types of inappropriate interactions with children. There is a crime called lewd molestation that can include the inappropriate viewing of children in a state of undress. It uses the term the child's body for the purpose of sexual gratification. Now, most likely, if they do an unreasonable search because they think the child has cigarettes, it's not going to meet that statute, but it could still potentially violate other laws. So your child may have some recourse. And of course, there's private civil law that could come into play too, such as intentional infliction of emotional distress, or in the case of any kind of a touching, it could be a civil battery if it's unreasonable. However, the thing that's important to understand is the Constitution does not apply to private schools as a general rule, except for one situation. If the police specifically enlist the help of the school to conduct a search. So, for example, let's say your child is suspected of having a weapon, and the school calls the police, and rather than search the child for the weapon themselves, the cops say, "Here, you school, you search this child." They have to have probable cause. At that point, the Constitution would apply because they're acting as an agent of the state. But that is really about the only reason why the Constitution would apply to a private school. If you are dealing with a search and seizure issue with your child's school placement, it's important that you talk with a good lawyer, because there's a lot of nuance when you're talking about search and seizure law, and it is a complicated area of law, and sometimes one rule applies, sometimes another rule applies. You need a good lawyer. One place you can, if you want a good lawyer, you're welcome to call me. I am an attorney with the firm of Fry and Elder, and I can be reached at 918-585-1107. Thanks, guys.